she is. Commissioner Carrion, we do have quorum if you need to leave at any time.
Great. Thank you all so much. It's a pleasure to be back on the board, and I'm excited to work with all of you. I am currently in Chicago for a pre-scheduled business meeting. So for that reason, today I will not be able to participate, but I'm excited to dig in with all of you and keep doing some great work.
Terrific.
So thank you all.
I'm glad you could join us.
Thank you.
Okay, we can begin at any time, Mr. Chair.
Okay, well, the February meeting of the California Law Revision Commission shall come to order. A quorum is present. Let's see, I guess first order of business is approval of the minutes from the January meeting.
I move to adopt the minutes.
There's been a motion. Is there a second to adopt?
I'll
the meeting?
second.
Any questions or comments about the minutes? Seeing none? Yeah.
Commissioner Huebner, one of the changes in the last 10 years is we're now required to do roll calls on votes because we're doing the Zoom. So with the chair's permission, I'll call the roll.
Thank you. Yes.
Commissioner Carrillo,
Aye.
Commissioner Huebner,
Aye.
Commissioner Jenkins,
I was not at the last meeting, so I think I should abstain.
okay. Commissioner King,
Aye.
Commissioner Simpson.
Aye.
That item is complete. Thank you.
Okay, on to administrative matters, and a matter we've all been looking forward to with some sadness. but anyway, Brian?
Mixed emotions, let's say.
Mixed emotions.
As we discussed at the last meeting, this is Barbara's last meeting that she's planning to attend because of her retirement.
I object.
Second.
And, you know, we wanted to properly recognize her for her many years of service, and the chair was instrumental in working with his many connections in the legislature to arrange for a resolution honoring Barbara and her service.
Wow.
And I would like to share it if I may. Everyone's seeing that?
Yep.
That's amazing.
Since we're not, if we were in person, I'd be holding it up and
Right.
have much more presence, but it's a Senate resolution, and I will just read it since the print is too small. California Senate resolution by the Honorable Robert M. Hertzberg, Senate Majority Leader Emeritus, relative to commending Barbara Sandra Gall. Whereas Barbara Sandra Gall, Chief Deputy Director of the California Law Revision Commission, has distinguished herself in nearly 3 decades of service to the Commission, the California State Legislature, and the people of the state of California. And whereas throughout her career, Barbara Gall has played a leading role in the development of numerous statutory reforms to improve the clarity, fairness, and effectiveness of California law. And whereas Barbara's work has included the development of thousands of code revisions that were necessary to correctly implement tectonic changes to the California's trial court system in the 1990s, including the elimination of municipal and justice courts and the shift from county funding of the trial courts and employment of court personnel to a system of state funding and employment. And whereas responsible for significant improvements to the law that governs trial practice in California, including reform of the hearsay rule, best evidence rule, waiver of privilege, and confidentiality of mediation communications, Barbara Gall has additionally prepared successful recodifications of the deadly weapons provisions of the Penal Code, the California Public Records Act, and the Civil Discovery Law, greatly improving the accessibility, user-friendliness, and future maintenance of those important bodies of law. And whereas Barbara Gall led the successful effort to enact California's adaptation of the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act, a statute that will reduce the difficulty and cost of caring for a dependent adult when that care involves multiple jurisdictions. And whereas as a critical member of the management team of the California Law Revision Commission, Barbara Gall has helped to steer the agency through repeated state fiscal crises, the creation of an entirely new law reform body, the Committee on Revision of the Penal Code, and the COVID-19 pandemic health crisis. And whereas Barbara Gall's thorough professionalism, keen intellect, fairness, decency, and warm collegiality have earned her the respect and admiration of those who have had the good fortune to work with her, including numerous members of the California State Legislature, as well as their staff. Now, therefore, be it resolved by Senate Majority Leader Emeritus Robert M. Hertzberg that he takes great pleasure in extending to Barbara Sandra Gall all due recognition for her many great accomplishments and for her exemplification of the character and competence that mark the best of those who serve the people of the state of California, and conveys his appreciation for the many contributions she has made to the California State Legislature and the administration of justice for all.
That's fantastic.
Wow. Wow. Well, thank you. Thank you very much for your kind words and this recognition of my work for the commission. They mean a lot to me. I have such respect for this group and the others, commissioners and staff that I've gotten to know through the years. I really value your opinions, and I've tried hard to make a positive contribution. And I'm just flabbergasted by this wonderful resolution. It makes me feel like I succeeded to some extent. It's been an honor and a privilege to serve this commission for so long, to have met so many interesting and talented commissioners and staff and other people along the way, and to have learned from you as we tackled a wide range of challenging legal problems together. I'm really excited about welcoming back Commissioners Huebner and Carrion today. I think that you'll be a particularly strong group of commissioners now, and I really look forward to seeing what you accomplish together. As always, there's plenty of important work to do, including the new study of the emergency-related reforms, and perhaps soon also the study of antitrust law and its application to technology companies. The work of the commission is usually lower profile than I think that study is going to be. And it's slow paced and often incremental. But the commission really, when you look back at it, the commission has an impressive body of achievements, and looking back at all the different areas of California law that it has touched, its fingerprints are all over the codes. The hundreds of court decisions that refer to its work, and the standard of excellence that the commission has maintained year after year. And I think that track record is especially notable because the commission's a low budget operation in which the commissioners essentially donate their time and expertise as a true public service on top of their regular jobs. And because the staff is tiny and stretched in many directions, but it's also determined and versatile and dedicated. Brian Hebert's leadership for the past 15 years has just been outstanding. I know you'll be in good hands when I'm gone. And it's no accident that there's hardly any staff turnover at the commission. It's a great place to work. The commission's transition to Zoom meetings went much more smoothly than I ever would have imagined. But I do think there's still something special about interacting face to face, some extra synergy and stimulation that results from that. And so I hope that the commission will continue to make good use of Zoom in the future, but will also at some point be able to resume meeting face to face at the Capitol from time to time. When it does, I'd love to see you all in person. In the meantime, I'll miss working with you. Please keep in touch. Don't ever hesitate to call on me if I can ever be of help. Thank you again for everything, and especially for your friendship and respect.
An incredible legacy, Barbara, that few people can aspire to. So your work, as you can tell, will go on for a long time. All the stuff you created, it's incredible.
Thank you.
Rick, if I may, I want to personally
Yes,
thank
yes,
Barbara
please.
myself. I've worked with Barbara for over the last 10 years on this commission, and for all the new commissioners who think that things have run very smoothly, I can't emphasize how incredibly difficult the work was during the 4 to 5 years of mediation confidentiality analysis that Barbara did probably 90% of. I'm not being melodramatic when I think the fate of California litigation was hanging in the balance, because we had dozens and dozens of people come to our meetings demanding that we make certain decisions in a certain way to either eliminate mediation confidentiality or to preserve it. And Barbara literally went and read every mediation statute and case in all 50 states and gave us an enormous overview of a subject which was highly complex and in which California was an outlier in many ways. And the commission was under a lot of pressure to come to some decisions. So it was only because of Barbara's guidance that we managed to get through that issue. And the legislature was also enlightened by her massive amount of work. And David, those of you in academia, you really should go through the old archives of what's posted about mediation confidentiality. Someone could easily get tenure writing three books on what she unearthed, because no human being in the history of the nation has read every statute and every case involving mediation confidentiality ever published. And I say that with some confidence because I read all your summaries. So that was just, obviously only probably, 5% of everything you've ever done here for us at the commission, but it was the 5% that I personally witnessed. And I just know that there were hundreds of hours, thousands of hours put into that project. And I think ultimately the legislature came to the right decision in preserving mediation confidentiality. And I'm sure many staff members in the legislature were enlightened by your guidance in making good decisions in that regard. So I personally thank you, and the state owes you a debt far greater than what that resolution alludes to.
Mr. Chair, if I may join in thanking Barbara for her service. Barbara, I think you and I served together about 7 years previously on the commission. You did extraordinary work, sometimes under battle conditions. I remember how contentious Common Use Development Project was, as well as the sentencing enhancements, where we regularly had militia commanders in the audience wishing to speak. And your work over that period was exemplary, both in terms of the substance and in terms of keeping the commission's docket moving fluidly, despite those often contentious public hearings. I'm very sorry to see you go, but I'm glad that I didn't miss you completely this time around.
Well,
thank you for your service.
Thank you all for your really kind words. I'm overwhelmed. I can't take credit for common interest developments, or for the sentencing enhancements. That was Brian. but we worked on the trial court restructuring together, David, and I hate to tell you, but there's still some of it for you to finish up. So it's great that you have that background to bring to the commission as it tries to mop up the last few ends of trial court restructuring and all the other things that you bring to the commission. I meant it when I said I think this is going to be a really great group of commissioners, and I'm really sorry to be, in some ways, to be missing out on this phase that's coming up, because I think you're going to do some great things.
Terrific. Thank you so much.
The chair, Mr. Chair, I see a hand in the audience. And
okay.
I'm guessing somebody wants to add to the, oh, it's gone. Never mind. Not that they don't admire you, Barbara, but they're gone. I can't let this go without saying something. Most of what I meant to say went into the resolution, except for the more personal parts, which I'll save and share with you. I'm going down to Palo Alto next Tuesday to give Barbara her physical copy of the resolution, and we'll have lunch and we'll talk then. But just to give a broad brush, we're so small as an agency, and it's been critical for me to have her as a partner in terms of the management issues, aside from the stellar legal work and the unflappable presentations and meetings, et cetera, despite plenty of reason to flap. It's just been great to have someone to partner with me and help me deal with management stuff, which, I went to law school, not management school. So we muddle through together through many different difficulties, and it's greatly appreciated.
Thank you.
Just don't flunk retirement like, me.
Well, you seem to be doing pretty well at it, Commissioner Simpson.
I do see the hand back up. Do we want to see? It's Marjorie Murray. I'll allow her to talk, and we'll see if this is intentional.
Okay.
She's currently muted. Marjorie, did you want to say
No,
something?
Brian, can you hear me?
Yes.
Yes.
There's something wrong with this setup here. No, although since I'm at the podium, Barbara, I want to thank you for all the help you've given me over the years. I really have appreciated your work and your responsiveness to many of my questions.
Thank you, Marjorie.
Okay, so with great thanks to Barbara, do we want to move on to the next item? In the agenda?
Sure. Report of the executive director.
Thank you. We have a couple of absences today to note. You've probably already noticed. Commissioner Kudos let me know she wouldn't be able to be here today. And Commissioner McAllister she's in a planned leave for medical reasons, no crisis, she's well, but she told us in advance she wouldn't be able to be here today. We've already had a chance for introductions with Commissioner Huebner and the members he hasn't met before. Looking forward to working with him. He was served on the commission over 10 years ago, I believe, multiple terms. And Commissioner Carrion, who could not be here aside from the very brief appearance at the beginning, another veteran. It's very nice to see reappointments because these are people who understand the culture and process well, and so we'll be able to hit the ground running. Regarding the agenda, there was a memorandum 2215 for the fish and game study, beginning the analysis of the comments on organizational issues that was postponed at the request of the Department of Fish and Wildlife. They wanted to be sure to have a full complement of people here to address the commission about the matters to be discussed in that memo, and they had a hard conflict with a meeting of the Fish and Game Commission that's going on apparently right now. So we'll take that up in March.
Good.
That's all I had for the executive director's report.
Okay, thank you, Brian. Commissioner suggestions? Any members of the commission have study topics, items they want to bring to our attention? Hearing none, seeing none. And then Brian, handbook on practices and procedures.
Yes, there's one item I should have mentioned earlier. The text of the resolution that I read, I would like the commission's assent to putting that in the next annual report.
Oh, yeah.
Okay, I won't take a roll call on that. We'll just present it as part of the presentation of the annual report. You
Sure.
can vote on it then. Okay, memorandum 2210 is a very brief memo about our handbook of practices and procedures. I need to make a note. I should get a new version of that to you, Commissioner Hebner. It's been substantially restructured since you served. But what we're talking about in this memo is the addition of a provision to memorialize a matter that we discussed at the last meeting, which is questions had been raised about the scope of the power of legislative members of the commission to act as commissioners. And we received, we saw guidance from the Legislative Council staff that analyzed that question. And I explained in broad brush what the result was at the last meeting, and the decision was made that we ought to memorialize it in the handbook. So that's what this memo presents, is just a provision to help us remember the issue and the proper treatment of it. The language includes some touchstone language from the opinion and from the case law, but it tries to ground those principles in sort of concrete terms, in terms of the kinds of things that commissioners are called on to decide. And I ran this by Commissioner Jenkins, and she had her staff review it, and they had no concerns about it. And so first, I guess if there are any questions about it, we could discuss it. Otherwise, it would be a question of whether you're prepared to approve including it in the handbook.
Just a quick question, Brian, and maybe Kara. I thought it was fine, and actually it reflected well the information we got from council. The only thing I was wondering if it made sense to add to the list of 6 was making it clear that legislative members can participate in electing chair and vice chair. I don't think that implicates the sovereign powers of the state.
I had thought about that. I
Yeah.
had thought about including that, and I don't know where the line is.
Oh.
I don't fully understand the concept of implicating the sovereign power of the state. I mean, the guidance we got, for example, was no personnel decisions, no contract approvals. But those are things that legislators can actually decide for their own body, right? And so legislators clearly can be involved in the selection of their own leadership and their officers. But to the extent that it's about running the agency, if that's what implicating the sovereign powers of the state means, then I was not entirely sure about election of officers.
Okay.
Brian, would you think that, oh, I'm sorry, Victor. I didn't mean to cut you off.
Yeah, Victor.
Just as a side comment, as a practical matter, our legislators are very busy. and I know a lot of commissioners are new, but they've really shown up and no criticism of them, they have other things to do. They've only really shown up to a literal handful of meetings in the 10 years that I've been here, probably less than 5 have we ever seen a legislator out of all the meetings I've been to in the last 10 years. So I don't think they're going to volunteer or want to be nominated to be in a leadership position on the commission. After all, they're asked to be on leadership commissions on many committees in the Assembly or the Senate. So in some ways, we may not need to overthink this. I don't think it's ever going to come up.
Well, no, my comment was about, would they be able to participate in the election of someone as chair or vice chair? Not that they would become.
Oh, okay. I'm
chair,
sorry,
vice
I
chair.
misunderstood you. Yeah, because we had an earlier discussion about whether or not they could serve as well. But at any rate,
So
in many ways, we don't need to create work or have a heck of a lot of discussion about those issues.
no,
Because if we actually went through the roll calls, I would think that I don't believe they've voted on any of those issues in the handful of meetings that they've attended in the last 10 years that I've been here.
I think that's right.
Literally, I've never voted for who was going to be chair or vice chair.
Okay. Commissioner Carrillo, you started to say something?
I'm good. I changed my mind.
Okay. Kara, any thoughts?
You know, my just personal inclination is that, but the chairs aren't in the same vein as personnel who are hired to work for the commission. So to me, it seems like it would likely be okay. But if we want to, avoid any type of controversy in the future, maybe it's best to leave it.
Leave it blank. Okay. That's fine.
I don't think anyone would challenge it, that's for sure. But just to be clear and not present any type of conflict that could be read later.
Yeah, part of my goal in this language is to create a bright line and steer clear of it.
Okay. So I'm fine the way it is.
So I guess I need a decision on whether to include it in the handbook.
Is there a motion to include this in the handbook on practices and procedures?
So moved. Oh, Kara was first.
Okay.
It's been moved. It's been moved and seconded.
I'll call the roll. Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
Okay, that's unanimous. Thank you. That completes that memo.
All right. Item 3, legislative program status report. Brian?
Yeah, this is me again. Memo 2211. It's just informational. And it's still early days for this year's legislative program. And I'm glad to say that everything is continuing to move on the expected track. We've had an introduction by Assemblymember Manchin as AB 1716 of our 2 small proposals relating to the process for disposition of a decedent's estate without administration. We also have been told that the hazardous materials recodification has been introduced. I didn't check this morning to see if it's live on the website yet, but as AB 2293, which is the actual recodification proposal, and 2327, which is the cross-reference corrections. And that is, I believe, Kristen, tell me if I'm wrong, authored by the Assembly Committee on Environmental Safety and Toxic Materials.
That's correct. And I did check this morning and I saw the main recodification, but I did not see the cross references show up yet. So I'll keep an eye on that.
Okay. The intention is that the public records cleanup will be taken care of through the annual maintenance of the codes bill. And I understand that that's in progress, and I'm optimistic that that will work out. And the only other thing I mentioned in the memo, I believe, is that we're keeping our eye on the resolution that Barbara mentioned earlier, ACR 95, which, if approved, would assign the commission a study of antitrust law. That was introduced last year. It has been referred to the Senate. It's in the second house now. It's been referred to the Senate Committee on Judiciary, but not yet heard.
Okay.
So we're watching that, because if it survives into enactment, then we'll have a lot of new work to do.
Got it. Got it.
And
Okay.
that's all I have on the legislative program.
Great. Thank you. Item 4, emergency related reforms. Kristen?
Yes, that's me. Good morning, commissioners.
Morning.
So Memorandum 2022-12 introduces the commission's new study on emergency related law reform. So the beginning of the memo sort of recites the commission's history with respect to the COVID-19 pandemic. Once the pandemic got started, the commission decided to devote some of its resources to emergency related issues. The memo includes kind of a brief note about what the commission has done so far, but the commission also sought new authority to work on emergency related issues more broadly. Previously, the commission was sort of operating under its existing substantive authority to focus on specific topics. And in this case, the memo, page 1, presents the language that was added to the commission's resolution on the commission's request. And in the new topics memo, the commission decided to go ahead and commence work on this very timely issue. So the memo discusses briefly 2 topics that the commission had tentatively identified for work in this area, both of which relate to the governor's powers, specifically focused on statutory and regulatory requirements in an emergency. And those issues are largely governed by the California Emergency Services Act. So the remainder of the memo discusses the Emergency Services Act, presents focusing specifically on what the governor's powers related to statutory and regulatory requirements are, because the Emergency Services Act is pretty broad. There's a lot of material in there. A lot of it relates to emergency planning. It establishes the Office of Emergency Services, and those issues the staff sort of set aside and really wanted to target in on what can the governor do related to a state of emergency. And so the Emergency Services Act empowers the governor to proclaim a state of emergency. And once the governor does that, the act provides certain powers that the governor can use. Those powers are presented in the memo. Let me get the page number on that. That is on pages 5 and 6. Those bulleted items are the statutory language that authorizes the governor to take action in a state of emergency. Those are pretty broad. They're not very, and that may well be intentional so that the governor can do what's needed. But those powers are temporary. They only last for the proclaimed state of emergency, which the Emergency Services Act requires the governor to terminate when conditions warrant. In addition, the legislature is empowered by concurrent resolution to terminate the state of emergency if they determine that the governor should no longer be exercising those powers and the emergency is resolved. The memo also provides kind of a brief description of what's happened, very brief. The governor did proclaim a state of emergency back in March of 2020 related to the COVID-19 pandemic. And since then, there have been numerous executive orders related to the COVID-19 pandemic, and some of which focus on statutory requirements. Others focus on, different types of acts that the state needs to take to respond to the pandemic. So the memo notes that, as in many of the states, these acts have not been without controversy. The legislature in both sessions since the pandemic has introduced concurrent resolutions to terminate the emergency. Those did not pass. A number of the governor's acts have been challenged in litigation. There's a footnote that flags just a few of those items. And those are actually things that we'll be looking at going forward. This, of course, I want to note that this is a bit of an unusual area for the commission because there's a lot of legislative interest and activity on this topic, unsurprisingly. And so that is, the memo does not note that, but we will be looking at the legislative actions this year, what's going on in the legislature related to the Emergency Services Act, so the commission can figure out where we fit in that picture. And the bill introduction deadline is tomorrow, so we didn't want to act too quickly, but we'll be doing that going forward. So sort of to wrap up, the memo does note that there are some very broad constitutional issues that could be implicated in this study. The litigation around the Emergency Services Act has involved delegation of power or delegation of authority issues, freedom of assembly, free exercise of religion, like big issues. So depending on what direction that this study takes, the commission, we may need to look more closely at those issues. To the extent we want to try to provide more specificity about what the governor is empowered to do, we're going to have to be aware of those limitations. Finally, the memo talks about the next steps in the study work. It mentions judicial decisions. As I mentioned, we'll also be looking at the legislative activity on these issues and stakeholder outreach. So I do want to note the commission has directed staff when we commence a new study to discuss stakeholder outreach We welcome any suggestions from the commissioners of who we should be reaching out to. There is a relatively new email distribution list that the commission has around emergency issues, but it's likely that a number of people on that list were interested in the commission's work on common interest developments. So we'll be trying to expand that list, focusing on, entities that are involved in emergency response issues. Any suggestions would be welcome, but as the memo notes, people can also sign up themselves to join the email distribution list on our website. We don't require a formal commission decision on this memo, but I do want to just open this up to the commission and see if the direction that the memo presents is that the direction that the commission wants to continue to go, or if there's any other topics that the staff should be looking at going forward in this study. So I just want to see if any of the commissioners have any suggestions on that issue.
Any thoughts or suggestions or questions from members of the commission? Yeah, Commissioner Carrillo.
I apologize if I missed it in the detailed listing of things that this is going to be looking at. But one thing that has jumped out in the discussion and coverage about the emergency actions in the last couple of years is the adequacy of the emergency brake, which is the legislature's ability by joint resolution to declare an emergency to be over. One point of view is that is an excellent emergency brake. The legislature enjoys a supermajority in both houses by one party, so theoretically it should be fairly easy to achieve a joint resolution to end an emergency at any time the legislature wishes, and that's all we need. The counterpoint that people make is that the legislature frequently fails to get its act together on things. It has difficulty moving quickly and with consensus on contentious issues. And so it's not really much of an emergency brake at all. So there's a debate about that point. And one recent counter example is what's going on in Canada. So as of a week ago, I didn't know anything about Canada's Emergency Declaration Act, but now I do know a little bit about it because it's been in the news. And one interesting feature of it is that their emergency brake is in stages. So within a week after Canada declares an emergency, its parliament has to validate it. So rather than it being a veto like ours, it requires an affirmative action to sustain or maintain or validate the emergency declaration. And then I believe there's a further possibility for a later emergency or emergency brake to end it by a similar joint resolution. So I'm not articulating a position on this. I've written about this a little bit, and I have some thoughts in both directions. But it's maybe something we should look at, because a lot of, Kristen, a lot of the discussion and a lot of what's in the memo now is about, well, what can we do with this? But some of the controversy or pushback on the emergency actions that we've seen in the last year has been, okay, the conversation is always, what can we do with this? What are the risks and how do we prevent this from getting out of control? And it hasn't yet, which speaks well of, the good intentions of many of the actors here, but it's a common thread, and I'm wondering if we should talk about that.
Yeah, no, I think that's a good idea. I have seen some different, not necessarily in California, but kind of across the states. I've been looking at what's out there. There's a lot of material being gathered, and there are some different directions that states are taking or trying to take about whether the legislature actually needs to approve like a continuation of the state of emergency beyond a certain point. So there are, like you said, some different approaches that we could consider, because right now, I mean, the California statute does not provide any termination date. There has to be an act to terminate. Right.
Yeah. And you raise another good point, which is that, we could evaluate what other states are doing, and they are all over the map. I think one of the things that one of the reasons we're confronting this particular aspect of the Emergency Services Act for the first time now is that a characteristic of emergency is just that they're typically of short duration. The earth stops shaking, the fire burns out, the flood waters subside. It's extremely rare. The medfly is the closest example I can think of something that went on for quite some time. And even that didn't last nearly as long, nor was it as bad as the pandemic. So this is really the first time that we've had to confront the application of the existing ESA framework in the context of something that that is endemic and potentially, very long lasting. So for years, people like me who have nothing better to do have speculated about, well, what if a governor declared an emergency against the drought or cancer or homelessness or AIDS? The drought one actually did come to fruition because Jerry Brown, as I recall, did declare a drought emergency. But droughts, as they do, they come and go. The pandemic is likely to be around for quite some time in some form or another. So again, it's a unique context of what do you do with something that basically won't go away? At some point that stops being an emergency and it turns it into a chronic condition. And the ESA is not really set up to find that line because, wars end, lightning strikes once, that kind of thing. So there's been some play in the joints, so to speak, about adapting the ESA to this unique context. And so I think there's a conversation to be had there.
Yeah, no, that's a very, sorry.
Go ahead.
I was just going to say, no, I think that those issues are definitely things that people have been paying attention to around the US. And I think you're pointing to kind of a tension where, while we may have some of the conditions that still say there's a public health emergency, do we still need sort of the nimble response that maybe was required to, act initially, but how long does that continue?
Yeah, and the ESA is scalable to a certain extent. You can scale it according to geographic region. Counties can declare emergencies, or you can have a statewide emergency. But once you declare a statewide emergency, that it really is, it's a hammer. Once invoked, the emergency powers they're quite broad, and to my knowledge, there's no way of partially invoking the ESA. It is all or nothing. So I could see an interesting conversation about how you could adapt the existing ESA framework to a unique circumstance like the pandemic. And the counterpoint is, well, maybe this is a one-time thing. And, it's a little bit like, are legislators ever going to show up and vote on the commission? Well, I guess it's theoretically possible, but do we really need to spend a lot of time working on this? I don't know.
Along the same line, I was wondering if the legislature's ability to curb the governor's powers in an emergency, it sounds like, and Kristen, correct me if I'm wrong, are limited to, you can declare the emergency over.
Right.
Then,
Right.
Are there places where, in a similar circumstance, the legislature has the authority to halt a particular action the governor has taken, not to declare the emergency over, but to say, sorry, you can't impose mask requirements on X? I don't know if that's
Kristen's right. I have a little bit of an answer. It looks like Kristen's drawing a little bit of a blank.
Yeah, no, I'm not sure.
The short answer is yes. The other states that have similar, comparable ESA frameworks, there's a range basically. So legislators or legislatures in other states, they've vetoed or kiboshed specific actions. Some of them have just rescinded the entire emergency declaration. There's one state that I'm forgetting the name of. They basically undid their entire emergency declaration framework and just revoked those powers by the governor, so they don't exist anymore. So that's another interesting point, that whereas the governor's emergency declaration invokes the whole of the ESA, right. It's binary, and it's also so with the legislature. They can end the emergency, period. It's also binary, all or nothing. So again, the ESA is not. In this particular context, I think we found that it's not particularly flexible. It's actually designed quite carefully to be very flexible, but this is the one rare circumstance where it doesn't cover this scenario very well.
And I'm curious about the litigation. Does it? As I was reading it, the legislature acting by concurrent resolution to impose something in public policy is kind of extraordinary.
I think so. Well, you spent more time in the legislature than I did, so you tell me.
And so I was curious, has that issue come up in the litigation, at least here in California, about is acting? Can you act by concurrent resolution, not by statute?
Oh yeah,
to impose, undo something that was authorized by statute.
The short answer is yes. The So disclosure, I was amicus in a case where some members of the legislature, Gallagher and Kiley, sued the governor over his emergency powers. So that's why that's my context here. The litigation came at it from a slightly different point of view, and the issue of whether the legislature could, by concurrent resolution, end an emergency. That was something that the governor's team used mainly to defend itself against charges of, assuming dictatorial powers. Well, look, the legislature can end this whenever they want.
Yeah.
So it was less of an issue from the perspective that or the way you're framing it as, well, can the legislature do this piecemeal, or can they use it to do affirmative things, or to veto specific parts of a governor's? Can you veto by concurrent resolution just one part of an executive order, or a single executive order? Because Governor Newsom issued, I don't know, like 50 some executive orders in the last couple of years on the pandemic. So it was in the context of it being an emergency brake to prevent, like us trending towards martial law rather than creative uses of the emergency brake by concurrent resolution. But that's also something that could be part of the discussion.
Yeah. Okay. Interesting. So Brian, do we need to take action on this, or is this this is just information?
No, it's mostly information and an opportunity for commissioners to weigh in on direction of the staff's work.
Okay. And any other commissioners want to weigh in?
Mr. Chair, just one point. I agree with everything I've heard about the scope of the analysis. There is one issue, though, which I didn't hear mentioned, which is if we're looking at how other states and countries organize their statute, I think it would be helpful to our analysis, if the data is available, to also look at what was the impact of the various mechanisms designed to limit or undercut executive authority. Because looking at just what the mechanism is doesn't tell us if the mechanism was wise.
So how were those mechanisms used in practice?
Well, how were they used? But then what happened? If a legislature decided made a political decision to remove something from an executive's declaration, and then the city was overwhelmed and destroyed by a flood, it would be useful to know that introducing a political mechanism into an executive decision created a certain result.
Yeah. David, Correa?
Yeah, that you raise an interesting point, and unfortunately, discussion about what kind of emergency brake to have, what you can do with it, when it can vote. At some point, you get into a purely policy decision about what is the best thing to do in an emergency, and the pandemic's a good example of that. So one debate has been between public safety versus the economy. Is making people stay home the best we can do for their safety versus it's destroying the economy and maybe we should just let people go to work. So the consequences of a legislature, for example, overturning a governor's mask order, at some point that turns into, it gets beyond the scientific data and gets into a policy debate about what losses are acceptable, basically. And so you see that in California's Emergency Services Act, the policy decision as it's currently written, it's designed to give the governor maximum flexibility, expressly so, it's right there in the statute, maximum flexibility to take command and sort out whatever needs sorting. And the emergency brake is designed to, in extreme circumstances, when a governor just really runs away with the ball and does something completely off the rails. That's a policy decision to grant a governor that degree of discretionary power in an emergency. You could make a different policy decision, as you describe it, to ride herd more closely and have much more of a power to rein in a governor. That's a design decision at some point. That's a policy decision. How much do we trust a governor, or how much are we willing to trust them? How much power do we want to have to claw that back and to override a governor's policy decisions in an emergency? That's a tough conversation,
but interesting.
It is, yeah.
So yeah, well, I will be, like I mentioned in the memo, looking at some of the legislative ideas that are out there in California. I don't know how soon I'll be able to get to kind of the broader, like what's been going on in other states and countries, but that is something now that I've got on the list to keep in mind. There are some good resources that have gathered the material, specifically, I think related to COVID, not necessarily emergencies more generally, but there are some very good resources that kind of gather what's been happening, and hopefully I can draw upon those to at least partially answer some of these very challenging and broad questions that the commission has been raising. They're great questions.
Krista, I have a couple of resources I can send your way.
That would be great.
I should. I'm the one who created this problem.
One thing Kristen mentioned that we're going to brief you on in the next meeting's materials, and it's going to require a decision, is that, you know, the commission has a historical disposition not to tread into areas that are under active consideration in the legislature, so as not to sort of impinge on or color their work. If we're going to proceed on this, I think that's going to be unavoidable to some extent. And so part of what Kristen is going to summarize in her memo for the next meeting is the bills that are currently pending to deal with some of these emergency power questions, and whether the commission feels that it would be prudent to step aside and let those bills proceed without our contributions, or whether we just go ahead with our work. And I think it's going to be difficult, unusually difficult question in this study, because there's a lot of interest in it right now, and it's urgent. You know, I mean, who knows when this emergency is going to end? It'd be kind of nice to get this work wrapped up pretty quickly and start realizing the benefit of it.
Right.
So not for decision today, but just sort of coming attractions.
Okay. Brian, I know there's one person in the audience has their hand up. I don't know if it's from this or not.
That was Marjorie. She's been popping on and off. We did hear from her when Barbara was being recognized.
Okay.
We'll see. I just authorized her again.
Yeah. I was glad you can hear me, Brian.
Yes, we all hear.
Yes.
I was glad to see the brief section on the intersection between emergency powers by the governor and its impact on the impact of that on both constitutional issues and, you didn't use this language, but civil rights, which I think is going to be immense. There's a partial listing of some of the constitutional issues. The civil rights issues are perhaps even broader, like the right to vote. I bring this up because, sorry, I lost my train of thought.
Well, it's okay.
Are you still there, Marjorie?
Yeah, I'm still there, Brian. I'm just trying to sort out what I want to convey here. That we've seen some examples of the interference of the emergency powers at the state capitol. That is the ability of the public to be able to participate in civic engagement. I mean, you know, the whole issue of doing Zoom meetings at public hearings has been quite problematic. And in my mind, that raises a related issue, which is the role of technology during an emergency, when the governor's office calls an emergency. Because as we know, the ability of people to participate and to get information about mask orders or public health issues or what to do next about COVID is highly dependent, at least in the minds of policymakers, highly dependent on technology, and not everybody has access to it in California. So I would recommend that, we would recommend that as even a separate section in this study. That is, when an emergency is declared, it has to be declared through means and through methods where the messages can be conveyed to the public. And not everybody in California has access to the internet to broadband. They're not tuned into this meeting. They're not tuned into the legislature and the way it is currently doing its business. So actually, Kristen, I would recommend that as a separate section in your study, the role and the impact of technology on and during an emergency.
Thank you for those comments. I've made a note of the issues that you raised, and yeah, no, it's an interesting issue how you make sure people are well informed and get the information that we need to give them during an emergency, because it's a challenge.
Well, it's not only giving emergency, but it's the ability of people to be able to participate. It's a two-way street. It's not a one-way street.
Mm-hmm.
People need, during an emergency, for example, I mean, this is a really obvious and simple example, to be able to vote. And now voting has become highly dependent on technology as well. So there's some very intimate intersection here between the power of the governor to have this broad power to declare an emergency and conveying the message and people being able to respond to it, but also continuing to be able to participate in government and even to get services from government. Emergency powers have cut off, I mean, just try to get a hold of the IRS these days. It's next to impossible. Or to get a hold of the Franchise Tax Board, next to impossible. Or to participate in public hearings at the Capitol, extremely difficult because the AT&T operators don't know what they're doing. So, you know, it's a two-way street here. In the suspension of civil rights and constitutional rights by the governor, and how all of that message is both conveyed as well as impact the right.
Thank you, Marjorie. I think Barbara, did you have something you wanted to add?
I do, but it's unrelated to what Marjorie was speaking about. So if somebody
Fine.
wants to follow up on what she was saying, they should go first.
Seeing no hands. Barbara, go ahead.
Okay, so I just wanted to say that, and mostly for Kristen's benefit, but also for the rest of you, during the commission's work on mechanics liens, which Commissioner Huebner will remember well, there were issues that came up about pending bills in the legislature and how to deal with those. And so there might be some references to that in the mechanics lien study. I know Stan Ulrich did a memo on sort of the overlap between the commission's work and the pending bills at one point. And I think that might be helpful to take a look at.
Okay, thank you, Barbara.
Thank you, Barbara. Okay, yeah, Kara.
So I just wanted to let Kristen know that and everyone, I am actually a commissioner on the Uniform Law Commission, and I am participating in a drafting committee that is looking at this very same issue. So to the extent that I can provide, information as we move along with that process, they're trying to develop a model law, obviously. So
Okay.
that might be helpful in this process.
Great.
Oh,
Yeah,
absolutely. Great, thank you.
Any other comments or issues to raise on this topic?
I see that Marjorie re-raised her hand after I removed her, so I think she maybe wants to have nope, popped off again.
Okay. Okay, thank you, Kristen.
Thank you.
This will be an entertaining one, I'm sure.
Certainly looks.
All right, on to item 5. Steve?
Yes, thank you. Good morning, everyone. We have 2 fish and game memos on the agenda. Neither should take too long to go through.
Okay.
The second, labeled cumulative draft, is purely informational. And unless anyone has any questions or comments, I won't discuss that one any further. The first one, labeled phase 1 public comment, is a recurring memo that we present each month with new content each month. For Commissioner Huebner, I just very, very briefly, we have been for some time considering revision to the existing Fish and Game Code. And each month we've been presenting public comment and analysis of public comment on proposed revisions that we had made in a tentative recommendation to recodify the entire code. We're not at this point doing that. Phase 1 is working on just revision to the existing fish and game code. And each month we present the public comment and our analysis of that comment broken down into various categories according to the nature of the comment and the nature of the revision. We have been presenting each of these categories as consent items. They're summarized and they're analyzed. And then I ask if any commissioner has any question or comment or objection to the staff recommendation, and then opportunity for anybody in the audience to also express their thoughts. And then I just ask if there is agreement with all the staff recommendations, and then we do a roll call. I don't mean to foreclose anybody from asking any questions or comments, but that's the method that we have found to be most efficient. This is only sort of one step in the process. What happens after there is an approval of the recommendations, excuse me, is that proposed revision of an existing section goes into this cumulative draft. Typically, that memo has an attachment to it, which has all the sort of tentatively approved decisions that the commission has made in the past. We will eventually get to a point where we will be done, and then we will have a content for a draft recommendation. So that's sort of a basic history. And so I will ask about this first memorandum, the phase 1 public comment. If anyone does have any questions or comments or objections to any of the staff recommendations in the memo.
Any commissioners, questions, comments, recommendations on the memo? I don't even have any snarky comments this time.
That's unfortunate. I wish.
I know.
Next time, maybe.
Seems fishy.
All right. Well,
Hearing none.
so seeing none, so each of the sections, there is a staff recommendation there. And so we need a roll call. I'll ask for a motion to approve the staff recommendations.
To approve all the staff recommendations in the memo.
Yes.
That's my motion.
Okay, it's been moved. Is there a second? Yeah, Kara seconds. It's been moved and seconded. Steve?
Thank you. Yes, please. Commissioner Carrillo.
Aye.
Commissioner Hebner.
Aye.
Commissioner Jenkins.
Aye.
Commissioner King.
Aye.
Commissioner Simpson.
Aye.
Excellent. Unanimous. Thank you very much.
All right. And
Anyone have any questions about the second memo, the cumulative draft memo?
draft, any questions or comments?
Okay.
Seeing none?
And I'm assuming there was nobody in the audience that had their hand up. or anything.
There's only, I don't see any hands. So I'm going to assume not.
Okay, thank you
Okay.
very much.
Thank you, Steve. Statutes made obsolete by trial court restructuring. Barbara.
Okay, well, this was a short memo. I was hoping to tie up one of the loose ends from the commission's work on what started out as trial court restructuring part 6 on court facilities. This memo relates to Government Code Section 76101.5 that has to do with financing of court facilities and criminal justice facilities in Lassen and Los Angeles counties. In 2019, the commission included a proposed amendment of that section in a tentative recommendation. Basically, the proposed amendment was based on the idea that the courthouse construction fund in Lassen County had been closed, and therefore the reference to Lassen County in this section was no longer needed, and the statute should be amended to delete it. The comments at the time were that there was some misunderstanding, and that no, the courthouse construction fund in Lassen County still did have some money in it, and it wasn't clear how that happened and what the status was, and people were going to look into it. And so the commission withdrew that particular amendment from the court facilities proposal. And this memo brings it back for another look. It turns out I've tried to drum up, contact the stakeholders and find out what's been happening in the last couple of years on this matter. As I understand from a contact at the Judicial Council, things really haven't changed in the past 2 years. But my prodding right now has helped move things to the front burner rather than the back burner. And so there's a possibility that there may actually be some action forthcoming fairly soon, at least I hope so. My recommendation would be to revisit this again in not too long from now. The most recent recommendation that the commission approved on trial court restructuring, the one that dealt with judicial benefits and various other issues relating to judges, but also included various miscellaneous things. That recommendation is still in the pre-publication phase. The proposed legislation has not yet been introduced. And so even though the commission approved it as a final recommendation, I think you could still slip in another amendment to it if it was appropriate. And so I would suggest that perhaps the commission revisited this later this year. I don't know if anybody in the audience is here to speak to this matter. If so, it'd be helpful to have them raise their hand.
Well, there's only one, besides Deborah, there's only one person in the audience whose name I don't recognize, but if this is an issue that they want to weigh in on, they're more than welcome to raise their hand. Seeing no hands. And so Barbara, the resource that we should be contacting later on in the year would be the Judicial Council or Lassen or both, or?
Well, what I did this last time was I contacted the Judicial Council. I sent a letter to the presiding judge and court executive officer at Lassen County Superior Court. Mm-hmm. And I also sent an email to the county council for Lassen County, okay, and copied Senator Dolly's office on it because they had sort of been monitoring the situation.
Okay.
And I think that would be, an appropriate group of people to recontact, I don't know, 6 months from now and just see whether there's anything that has happened and whether you can, just take this one issue and at least dispose of it. So it's one less thing that you have to think about with regard to trial court restructuring.
Got it. Okay. Thank you. Thank you. Any questions or comments from commissioners? Any questions or comments from the large studio audience? Seeing none, hearing none. Thank you, Barbara.
Well, I don't know if you want to vote on bringing it back or just.
I don't know, Brian. Is there something?
I don't think it's necessary.
So.
It's just a sort of process point that the staff commits to bringing it back.
Yeah. Okay. I think that's fine.
Okay. All right. Sounds good. Thank
Great.
you.
Thank you, Barbara. And then the last item on today's agenda, stock co-ops, RTODD.
Memo 2217. This should be quick.
Mm-hmm.
This is the culmination of the work on figuring out how to provide for owners of stock cooperatives the same transfer on death or similar transfer on death mechanism that's available to owners of other types of real property under the revocable transfer on death deed. At the last meeting, the commission made a decision on the only remaining issue to be resolved, which was whether or not to or how to amend probate code section 5652B. That decision was made to craft a narrow exception to the recordation requirements in that provision for restrictions in stock co-ops that arise out of the governing documents or agreements. And a draft recommendation is attached to the memo that implements that decision, both as in the proposed legislation and in the preceding narrative. And so the question is whether anyone has any concerns or suggestions about that implementation or not. And if not, then whether to approve the recommendation as a final recommendation for submission to the governor and the legislature.
Any questions or comments on the content on this matter? Seeing none, hearing none, is there a motion to approve this as a recommendation for the legislature?
So moved.
Been moved. Is there a second?
Second.
Okay. It's been moved and seconded and thirded. Brian, call the roll.
I will call the roll. Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
That is approved. And
Okay.
the memo is complete. We'll get that up on the website, and I'm not going to try to hurry this into any bill this year. I think we'll look for an introduction next year.
Okay, sounds fine. All right. That concludes the agenda for today's meeting. Any other final questions or comments from members? Once again, want to wish Barbara all the best. You will be missed. You will be missed.
Thank you so much. I was really touched today. Thank you.
And Commissioner Hebner, welcome back. We look forward to continuing to work with you.
Thank you.
Anything else for the good of the order? Hearing none, seeing none. See you all at the March meeting.
Thank you all.
All right, thank you.